item. So gender inclusive schools policy development. Jason McKay with Clay.
All right, as I previously had shared, our work in doing our response to public comment and being responsive, as we want to be, it became, we were notified that, this issue that we were researching, that the district does need to adopt policy and procedure as per RCW 28A 642080. Because of this issue, wanting to have an opportunity for the board to have some question and answer with our legal counsel, I thought it'd be good for us to have the legal counsel here in person and to have our audience as well to hear from the legal counsel and how basically from our legal counsel, what is it that we're going to need to, are we required to have the policy and the procedures as we move forward with this requirement to have the adoption of policy procedure. We don't have a current draft at this time for the board. This is more of a policy development discussion and an opportunity for us to hear from legal counsel about what will be required in this policy and procedures. So Jason, go ahead and share some information, and then we'll have a chance for some question and answer with the board.
Sure. Thank you, Dr. Finch, and thank you, school board, for having me here tonight. It's great to see your faces and to see you in person. I know I had an opportunity to meet with many of you in virtual meetings last year, and it's wonderful, I have to say, for my part, to be able to be here in person to see you. So thanks for having me down. So as Dr. Finch teed up well, and maybe before we get into the policy, as many of you know, just kind of a backdrop of the current law of the land and why we're even having this conversation. Ultimately, as of right now, but whether a policy or procedure are adopted or not, currently the law of the land that it is unlawful for a school district in Washington state to discriminate against or otherwise deny access to a student based on their gender identity or gender expression, which is what the law says. So what we're here talking about is not really about whether or not the school district is going to adopt the law. It's just whether or not it's going to adopt a policy. Ultimately, why we're having this discussion is because the legislature has adopted a law, as Dr. Finch stated, that is the correct RCW 28A 642080. And it's in the same section of RCWs that essentially addresses this issue of discrimination based on gender identity. Also near some of the other sections talking about harassment, intimidation, and bullying. So same kind of area. In fact, this statute was adopted about the same time as the harassment, intimidation, bullying statute was adopted. And so ultimately what this statute says is it says that school districts in Washington state by law are required by law to adopt policies and procedures which incorporate what the law says is it incorporates the elements of a model policy and procedure, which was adopted by WVSD, the School Directors Association. So they adopted a model policy and procedure. And ultimately, as they do, for those that don't know, WVSD adopts model policies and procedures all the time, and school districts essentially take those from WVSD and then they incorporate them into your own and tailor them to yourself. So this particular policy and procedure addresses a couple things. The policy, the model policy is pretty short. And again, Dr. Finch and I are going to work on developing something that incorporates the essential elements of what are in the model policy and procedure, but is also what he and I would think are maybe specifically tailored to this district, and that'll be presented to the board at the time. The policy is pretty short and it's got a couple of elements. One, essentially, that the school district understands, it acknowledges that it has to promote an inclusive school environment, which includes, again, not discriminating against students based on gender identity and expression. The second thing that it incorporates is to have a requirement per the law that each school district has to have a point person, a liaison, a person that heads this up. And that's the point, that person has to get trained, and that's the person that essentially monitors and ensures that everything is being done pursuant to policy and procedure. And then, of course, as is typical and common, the procedure is much longer, it's much more thorough, and it incorporates many things. And again, the procedure that'll be put in front of the board, again, Dr. French and I will work to make sure that it incorporates the essential elements of that model procedure. But it's going to address things such as a process for district officials to with when any issues arise, for any issues, again, some of the issues we've heard tonight regarding bathroom use and regarding locker room use and regarding pronouns and regarding names. It addresses issues with regarding records, name changes, what records need to maintain the birth name versus what records can be changed to adopt the chosen name, and essentially processes for how all of these things need to work. It'll obviously has a complaint process in it as well. If a student or family is alleging that the policy hasn't been followed or the procedure hasn't been followed, it will list a complaint policy or a complaint procedure, which will look very similar to the HIB complaint procedure. And then ultimately, it has some training issues too. Again, the law does not require that all staff are trained on an annual basis, but Dr. French and I will work up, I think, some good best practices language on ensuring that folks are properly trained. Because obviously, from my perspective as legal counsel, I think it's always really important that your policies and procedures are adequately portraying and communicating to all of your staff, obviously to all of your stakeholders, but particularly to your staff so they can understand how to address issues as they arise to make sure that they're not making any missteps. So that's what we'll be working on to get in front of the board for a first read at a future meeting. If the board has any general questions, again, as I always have to preface in these open meetings, is if you are seeking any legal advice, my suggestion would be not to do it here. But if you have any just general questions, please feel free to ask. I'm happy to answer them or attempt to answer them.
What kind of timeline are we looking at to develop this? It's becoming a hot topic, and
Luckily,
it's best that we attack this now rather than put this on the back burner. And I think we need to work hard at getting something down so that we can move forward.
well, I'll let maybe Dr. French address some of that in terms of timing, but I can tell you that he and I have already been working on that, and I don't anticipate that it's going to take very long at all. I think we understand that timing is of the essence, and it's the school board's desire to try to resolve this issue as quickly as possible. So we're working, again, working quickly, but also making sure that we're developing something that's sound, that it's lawful, and that it works for the school district. But Dr. Finch, if there's anything you wanted to add on that.
Right, we were notified that we needed to have that policy in place, and so I had contacted our legal counsel, and there is the model policy, so we began reviewing that. But rather than just to take it right to the board, I wanted to have a chance to have some question and answer with counsel and to do this policy development. But my plan would be at our next board meeting, we would have first reading of the policy and be able to have some continued discussion on that, and then continue with second reading at the following meeting.
Two questions. One, and maybe this might go to the legal advice question. So if you don't answer it, I understand. What if we don't adopt a policy? I'm looking at the statute right here. I don't see the hook for the consequence to the school district if we don't adopt the policy. Second question, while you're thinking about whether you want to answer that question or not, is there any litigation that you're aware of this is a state statute. Are you aware of any litigation in state court or in federal court dealing with this particular statute and its validity and constitutionality?
Sure. No, I'm not aware of any litigation that's pending over it, but I'm happy to review that. And I will review that just for my own edification. In terms of the first part of your question, I think I can answer it vaguely, which is the hook is in RCW 28A 642050, which gives OSPI the authority to take various actions against school districts for non-compliance with the provisions of the chapter. And that's where I think it hooks in 080. So that's where the legislature put the hook, because that was one of my first questions as well, Mr. Thorner. And that's what it is under, for those who don't have a habit of just reading RCWs, I can just summarize that ultimately OSPI has the legislature. And again, I don't know to what extent this authority has been challenged, but all I can say is what the legislature has stated and what's in the statute. And that's that OSPI has the authority to withhold apportionment, to shut down programs that aren't compliant, or to put the school district on probation.
And I believe the
so,
check-
so the question is, and I think I reiterated this at the beginning. There is a law that says you have to do this. The most important thing from a legal perspective is that regardless of the existence of a policy or procedure, that there's no actual discrimination occurring. That's certainly where the real legal problems are going to arise. In
Right.
terms of whether or not the school board should or should not do it, yeah, I would not answer that question.
Yeah, and you'll, I'm not, I would just want to be clear. I'm not suggesting that we don't follow the law.
Yeah, I mean, my easy legal advice that I can always give is just to follow the law.
Yeah. Yes, I'm not suggesting that we don't follow the law. My question is, I think that, and this is where I'm going to make just some comments about, is that I think that the challenge that a school board has is that we have goalposts. Those goalposts are set. Many of those goalposts are set by the legislature. Whether we want to follow those rules and that's the best thing for, we view that as the best thing for us, but we have to follow the law. So the problem is when I read this law and thinking about policies and how I look at policies, is we want to follow the law, but I don't want to set the school district up to fail, whatever that looks like. And it's when I read this statute, and when we get to the policy, it's going to be with that in mind, is how do we not set the school district, how do we follow the law and not set the school district up to fail? And, that's not a question. That's more of my commentary about the matter, but this is a really, one of the reasons why I asked the question before about the litigation and the interpretation and what a school district has done or not done is instructive to what we should do to follow the law. So I think it's one of many things that are imposed upon local school districts are these situations where, or these statutes that I just feel like set the school district up to fail. And that's just my personal opinion. And that's too bad because whether you're the transgender student or the parent of a transgender student, or you're not the parent of, or you're the parent of a non-transgender, I don't even know how to say that, a non-transgender student. I don't know. I'll just say, like many things that the legislature does, they are setting school districts up to fail. That's just my personal opinion.
Jason, I have a question for you as well. You said a moment ago that the law says we have to promote inclusive environment. So what does that mean legally? I mean, that's a pretty broad statement, in my opinion. So what do we have to do? What's the minimum and what's the maximum, I suppose, if there is such a thing in this kind of issue? What do you see as that meaning to us legally as a school board?
Well, yeah, obviously, and many policies, particularly the model policies that we see language like that is very vague, and it doesn't provide a lot of guidance. Ultimately, that's where I think the procedure comes in, is to try to explain or go into a lot of those areas that at least guidance has been released on specific issues like use of restrooms, like use of locker rooms, like use of pronouns, like names on school records. Those are the type of things that are addressed in the model procedure. And at this point would be what I would say we would have some guidance on, is what the courts would do if there was some lawsuits down the road, or what the EEOC might do. Or I guess in this case, it'd be the State Human Rights Commission.
Ryan, I also wanted to share response to Mr. Thorner's question. We have annually a financial audit, but then on a periodic basis, OSPI does a consolidated program review. And in those past, we've been required to show our non-discrimination policy and such. So I could see in the future, in the consolidated program review, that we would need to show this policy for gender inclusive schools.
And I have a follow-up question to my earlier one. So is there any of this legislation that is going to have subsequent action by the state to require additional steps that we can foresee? And I'm in part, I'm thinking of, if we're required to do certain things, we don't want to take half measures now. We need to figure out what the larger picture is going to look like for us.
Sure. Well, at this point, all I know is the state hasn't adopted anything different than what the statute has said and what the model policies and procedures that have been developed and what OSPI has stated. So at this point, I don't know that I know or can foresee whether or not there's going to be anything additional that's going to come down the pike. Obviously, that happens all the time. And oftentimes it happens where, kind of to Mr. Thorner's prior point, as you see litigation or things that come up, or as this gets challenged, as discrimination or retaliation claims are brought, oftentimes you get a little bit more information and interpretation from the courts, and which then causes, of course, everybody to have to adjust potentially based on what was said. At this point, we have what is in the statute and what's in the model policies and procedures and the guidance from OSPI. That's all we have at this point. But again, the thing is, whenever you have new laws, there will be challenges, there will be litigation, things may change, they may not, but there's always development. There's always case law, and things tend to develop and change. And that's, and I guess that's why people like me exist, to make sure that you keep up with those changes and staying in compliance. But it's still relatively new.
Mr. McKay, I know, and I have full confidence in you, and that you're going to develop, you and Dr. Finch and whoever, a policy that meets the law. But, my granddad used to tell me all the time that just because it's legal doesn't mean it's right. And that's the part we're going to hear as a school board, is from the constituents we have that don't agree with what's been passed down to us. And regardless of whether we're upholding the law or not, it doesn't serve the district well in times of levies and bonds and those kind of things that we need to maintain our funding so that we can offer the educational opportunities that we can do now. It's not an easy thing to face. And I understand, we appreciate your help and all that. And I'm not looking forward to some of the meetings here in the future, to be honest with you.
And I understand and appreciate that, sir. And I can, not that I've ever been in your position, so I can't completely emphasize or empathize with you, but I understand that oftentimes things are passed down, or had your fair share of mandates come down, and I'm not commenting on anything pro, con, or indifferent. But I understand that oftentimes these things puts school boards in very difficult positions. So I understand that. But again, to your point, Dr. Fench and I will do the best that we can to try to ensure that the district is following the law and doing things it needs to do, but also tailoring it as best we can for the needs of this district.
Thank you. Another question for you, sir. I'm probably going to be pretty inquisitive here on some of this stuff. As far as what you could read into the legislation itself, are there any built-in financial costs to school districts that you could see? Or financial,
You mean in terms of complying with the law?
exactly,
But
yeah.
potentially, well, one of the things that the procedure will address is the issue of developing neutral bathrooms or locker rooms if they don't already exist. Places of where students can choose to have privacy. So the district is going to have to take a look at its current facilities to determine if it has the proper facilities to comply. And that, to me, the immediate cost that I see is probably that, in districts ensuring that they've got the adequate facilities. Training of staff is obviously a cost in and of itself, at least in people's time and getting people to speed with this. Those are kind of and it just, without really thinking about it before your question, sir, those are kind of the initial costs that I foresee.
Another question. You mentioned that one of our major responsibilities initially would be to have a point person or a point of contact. Can you elaborate a little bit more? Exactly what does that person do? I mean, do they coordinate with the state, or are they just simply someone that things get reported to for the school district? Just curious what your perception of that responsibility is.
Yeah, I think the person is intended to really be a liaison with the state. I think that person is intended to be probably the point person in providing training to district staff as needed, because that's the person that's going to be needing to get trained by law, as the law requires, pretty frequently. So to me, I see this person as kind of having multiple different hats, but probably the most important will be ensuring that district staff are properly trained on ensuring that they're following and complying with policies and procedures. But I do believe that the intent, though, is that they're also a liaison with OSPI, and probably the contact person when OSPI comes calling to talk about what the district has in place.
And did I understand you to either state that either this person or the state is going to require all teachers or faculty to be trained on this?
No, the only legal requirement for training is this point person. The issue that the district will have to determine on its own, and the district has discretion, of course, as it tends to with certain types of trainings, is the district will have to determine to what extent it trains its staff or families or anyone else that it chooses to train or educate on this is up to the discretion of the district. It's legally required on an annual basis, like the point person needs to.
As someone who works in a school, high school, on a daily basis, supervision is key, huge in our world. And just to comment, that's something that I'm going to be looking for in that policy is set guidelines for supervision of those areas. So that would be key for me.
Understood.
One more question, I'm sorry. And I didn't catch all of this earlier, so excuse me if you talked about this and I just didn't pick it up. So you made some reference to a complaint procedure. Did I hear that right? Either we have to have in place or as part of this?
Yes,
process?
you'll have, like you do with any other types of claims for discrimination, you'll have an internal complaint procedure that students or families can follow. So that is something that, again, the school district has various internal complaint procedures, and it will have one developed. And that's one remedy that students and parents can choose to follow. They can also file complaints with OSPI, or of course they could go down the lawsuit route as well, go to the EEOC or file a lawsuit. But you need to have an internal complaint process.
And that complaint process is, there's no specific guidelines how the state would like to see that done. It's really up to the school district to decide what that procedure is going to be like, or each school district.
Yeah, typically, and again, we'll analyze, Dr. Finch and I will analyze what the model procedure has and determine if that works for the district. The state doesn't dictate exactly what that process needs to look like. The school district retains discretion to have a complaint process and review process that works for it. I think the important thing from my reading of the statute and from OSPI is that one is developed. Some that students or families need to have an internal opportunity to try to resolve issues and complaints, which as a school district, you would always prefer.
Thank you.
You're welcome.
I don't expect an answer on this now. Forward thinking. If we have let's say three facilities, we have a male restroom, locker room, a female restroom, locker room, and a general neutral restroom, locker room. If we deny access to a transgender student to one of those facilities, is that legal?
You're going to have a problem if you deny access. And you're also likewise going to have a problem if you force a transgender student to use the neutral restroom. The neutral restroom is intended for any student, regardless of gender, to use if they don't feel comfortable using one of the main restrooms. But I think if denying access, you're going to have, there's risk.
So I can get my head around this. Can you explain to me how, following the policy and all that, with OSPI, the legislature, passing the law, and OSPI passing to the school districts to develop the policies and procedures and all that, there's not another unfunded mandate that's been pushed down onto the districts?
It is.
Thank you.
Hence the comment setting us up to fail. I want to talk a little bit about process. It is our usual course when we and Dr. Finch outlined this, is that we have policy reading, first reading, the school board has an opportunity to weigh in, vote, pass, make some adjustments. Even though we pass the first reading, those adjustments come back and then we pass on a second reading. Mr. Mokel's point is well taken in that it would be nice to get to a final product on this sooner rather than later. However, given the interest in this, I might suggest a slightly different course than what we normally take. And this is what I'm thinking, and this is what I've been chewing on as I've been listening to Mr. McKay's remarks tonight. And that is that I'm really excited to see what you come up with. I think that I'd like to have what is being proposed get out there to the community as soon as is reasonably possible ahead of the next school board meeting so that interested people have the opportunity to weigh in on this. And that will be helpful to me on this issue as a school board member. As we process this, I probably would not suggest that the second reading occur at the ensuing school board meeting, that we give an opportunity to another opportunity for people to come forward. We can take all of that in. I know it comes at a cost to the district, but I really think that Mr. McKay needs to be, even if he's not here in person, although if his schedule permits, I think it's very valuable to have him here in person. I mean, certainly he can participate by Zoom because he lives in Spokane, but I just feel like that we want to try to take in all of the comment that we can, that we can, and have everybody have the opportunity to weigh in. I'm gonna caution folks, however, that based upon what I'm hearing tonight, and as I read this statute, we don't get to just do whatever we want to do, and there's going to have to be some sort of an intersection here that eventually, I wouldn't even say works, that we're going to have to come to on this. And I do think it would be instructive for you to but to hear that for yourself and advise us appropriately on, okay, here's what we're hearing. Can we do, is this policy adjustment of this procedure and how we want to incorporate it in the West Valley School District work? And I that's just as far as the process is concerned, I don't know if any of that makes any sense. And I'm sorry for my kind of rambling here, and I don't mean to. It's just a very difficult issue.
And for my part, obviously I'll defer to the board. You want to handle the process. For my part, I'm always happy to come down here and see you guys. And I always prefer to be here in person versus Zoom. I think it's a lot more personal. I frankly like to hear the comment, and I understand it as it's really my responsibility. As we always talk about, Mr. Thorner, and the laws, like there's always a floor that is dictated by the law, and always have to make sure that whatever you're doing, you're not going below that floor. And so it's working on developing something that's going to work and takes into account the comments, but also takes into account and is mindful of the law minimally requires.
Well, what I heard in Mr. Thorner's elocution was he just transformed us into OSPI and recommended you become the school.
No, I'm just saying that.
You threw him under the bus.
No, not at all. No.
To the extent that
I just think that I think that what I'm trying to say is, if I were Mr. McKay and he's engaged by the school district, if I were engaged by the school district to undertake this job of helping us comply with the law, when I'm the lawyer and I'm putting a deal together, I want to hear from the clients themselves what's important to them. And as the lawyer, I have to say, well, that's nice, but we can't do that, and here's why. And for us to play telephone, even through Dr. Finch, it's not going to help us get this done in an effective way. That's what I'm saying. Not trying under the bus. I'm trying to put myself in his shoes and say, okay, well, how am I going to help how am I going to help my client the best? And I think him being here is a material part of that process. And being involved and engaged in the conversation is a material part of that process.
And the timeline that you had suggested would be April 26th could be first reading, and then we would wait and come back May 24th for second reading. That would give enough time for our community to process this and to give comments to the board. But also, I do think it is a good idea to have Ms. McKay here in person.
I will
think
not
that's-
be at the April 26th. I will
Okay.
be out of the country.
Okay,
And if it was a May 24th reading, I will not be at that meeting.
okay.
And I would think it's important that the full board is at the meeting that we're
Right.
Yeah.
hearing that.
Did you say again, what is the deadline of policy in place? Is there a specific date that we must have this done by?
Yes. January 1st, 2020.
2020.
Yeah.
So we're already late.
Yeah.
And yes, we want to get this in place, but now I agree with Mr. Mokel that this is I mean, they're all important issues, but we need to have, I agree that we should have the entire board. I mean, you know, absent any intervening circumstances, the entire board should be present during these discussions. I think
If we
that,
moved it back next, if we could go May 10th for first reading and June 14th for second reading. Would that work?
I'm fine with that. I mean, I'm fine with that.
Can you have, Mr. Thorner had suggested that we put it out to the public to be able to look at it prior to that. Is there anticipated date that we can get that out so even we can look at it before that
Yeah,
May
so we-
10th meeting?
I know Jason and I could work on this and have it by next week. We can have a first draft.
June 14th.
Any more comments? Very difficult issue to tackle, probably one of the more difficult ones in some time. So this is going to be a real challenge and a real delicate balance to try and meet the conditions of the law and at the same time reflect the of our community fairly.
And to do what is in the best interest of students.
Exactly.
And that's what makes this difficult because it's very difficult.
Okay, anybody else up here? Questions, comments? Before we kind of open it up to the public portion of this discussion, and maybe let Mr. McKay get a start back home. Anyone?
He might want to be here during the comments that we'll receive.
That's a good point.
Now.
So
I'll stick around for the comments. And I just say, I understand that this is a difficult challenge for all of you, and I look forward to being there and to helping you through it. So, and I will stick around for comment.
Thank you for being here.
You're welcome.
Thank you.
I also think it's important that the community know that this is not a decision that we are going to take lightly. This is tugging at us. We are having internal tug of war ourselves. And however we decide is not going to come easy. So